The disciplinary process, termination, and dismissal as provided for by the Employment Act 2007. Thank you for continuing to follow us in our presentation on the Employment Act of Kenya 2007. I am Dr. John Chegenye, and I endeavor to guide you through these important laws. Previously, we did introduction, challenges, and key provisions of the Kenya Employment Act 2007. Today, we relate the disciplinary process to termination and dismissal. Let us look at the disciplinary process, termination, and dismissal as provided for by the Kenya Employment Act 2007. And we start this by noting that the Kenya Employment Act 2007's foundation is fair labor practices. These presentations we are doing are intended to empower you through knowledge. It is important to note that legal rights are your shield against unfair practices. This presentation is targeting both employers and employees. The objective of the presentation is to help you know your rights and specifically help you understand termination and dismissal. Help you identify the two core legal tests for a lawful separation. It is also intended to help you know your rights during a disciplinary hearing as provided for by Section 41 of the Employment Act. It will also help you to understand the remedies available for unfair termination. Let us start by looking at the definitions of the terms we want to use. Termination and dismissal are ways in which separation of employment is done, where the employer and the employee part ways. Termination is defined as the end of a contract by notice or mutual consent. It's also by resignation, when an employee resigns, or when a contract ends, it expires. That one is referred to as termination. On the other hand, dismissal is end of contract as initiated by the employer. So in dismissal, it is the employer who wants the employee to leave. In termination, they agree because the employee can resign or the contract of an employee can end. So dismissal, the employer can dismiss an employee on the employee's conduct, otherwise known as misconduct. An employee can also be dismissed if his or her capacity to perform is poor, what we call poor performance. And an employer can also dismiss employees on his own needs because of redundancy. Then he can terminate or dismiss the employees. And before termination and dismissal are done, we have golden rules that are supposed to be followed. And a lawful or fair dismissal must satisfy two tests. The first test is called substantive fairness, that the employer must provide valid and justifiable reasons for dismissing or terminating employment. This is provided by Section 43. Another test or rule is what we call procedural fairness, where before termination or dismissal is done, due process, what we call, it must follow a fair process as provided for by Section 41. The process must be fair. So Section 43 requires the employer to prove the reasons, not to state them, while 41 ensures that the due process has been followed in termination. Let us briefly look at the disciplinary process, which then gives what we call procedural fairness. The first step in a disciplinary process is what we call allegations and show cause. Allegations and show cause. So the Employment Act starts the disciplinary process at the show cause letter. However, progressive discipline often follows a sequence of steps. These steps include: 1. Verbal warning. So an employee who is misconducting himself, misbehaving, will receive verbal warning on his or her conduct. So the verbal warning can be several, and this just to give the employer an opportunity to correct his behavior. So when there are verbal warnings, as it goes, documentation must take place. If the verbal warning process starts, then the agent, who might be the line manager or the supervisor, must document the verbal warnings. Then after verbal warnings have been exhausted and the employee is unable to change, the conduct is not reforming, then this employee will receive written warning. This written warning is now what starts the show cause, is what we call the show cause. And in the show cause, the employee, if he doesn't change or she doesn't change, then a final warning is also written. And if there is no change in the final warning, then the employee is subject to dismissal. So that is what we call the disciplinary process, starting from verbal warning, written warning, final warning, and if there is no change, then the dismissal is inevitable. Let us look at the procedural fairness as it progresses. So before a show cause letter is written, the HR office or management is expected to conduct investigations on the matter at hand, on the behavior of the employee. These investigations are just to establish whether verbal warnings were done, whether the conduct of the line manager or supervisor were good, were preferable, or whether the employee didn't like the way the line manager was conducting the verbal warnings. And they will also determine the action of the employee when he was given the verbal warnings. And that is why documentation is necessary. If the investigation establishes that it warrants discipline, that the employee is required to be disciplined, then a show cause letter, which is an official written notice to employee, will be done. This letter must state specific charges or allegations and ask the employee why disciplinary action should not be taken against them. And if the employee has now been given the warnings, he has been given a show cause letter. He has a right to a fair hearing. And the show cause letter is not a conviction, but an invitation to a hearing for the employee to defend himself or herself. It only formalizes the allegation. And sometimes if the employee behaves well, changes his character, then disciplinary action can end there. And when an employee has been given a show cause letter, it is a requirement for that employee to respond in writing to the charges and address each charge factually and professionally. This is not a job. It is not time to go and sit with the other employees and discuss the management. You have a show cause letter, respond to it in writing and address each charge factually and professionally. It is mandatory for the employee to be allowed to be heard before a final decision is made. So the show cause letter is a step, and therefore the employee should be given an opportunity to be heard. The employee has a right during hearing to be represented by a fellow employee or a shop steward who is a union representative. When you are going to the hearing, it's your right to elect someone who you can go with to the display, to the hearing. And this person can be a fellow employee, or you can ask a union representative to come and help you. The purpose of this union representative is maybe to help you take minutes to ensure you stay calm and to guide you where necessary. He's not a lawyer, he's not an advocate. So just pick a colleague or a union representative to go and assist you. Take minutes and assist you to be calm, organize your work, and such things. On the hearing, the duty of an employer is to explain the charges in a language the employee understands. So if the employer also explains the charges in a language that the employee cannot understand, then he is required to explain it well. During hearing, decisions are supposed to be made, and as the decision is being made, the employee should ensure that minutes that have been taken accurately reflect his or her statements. There should no case of doctoring of minutes, and the statement of the employee should be clearly captured. The decision reached or outcome must be communicated to the employee in writing. So after the hearing, you need to get a written communication of the outcomes. And if it happens that the employee is dismissed, then the letter to the employee must state clearly the reasons for dismissal and the effective date of the dismissal. When an employee has been dismissed, the employee has a right of appeal. He can appeal the action, and the appeal can start from the internal mechanism. So they have internal recourse after dismissal. The in thing is for the employee to check for the organization HR policy to identify the appeal steps. Some of the grounds the employee can use for appeal include that the decision taken was unreasonable. or the procedures used during discipline were flawed, or the employee might have come up and got new evidence on the matter. So you can go and appeal. This appeal must be done within a period of not less than 14 days, but maximum better is 7 days. So appeal within 7 days. Let us look at termination and redundancy as provided. And termination, we have said, is end of contract by notice or mutual consent. So by notice, when termination is by notice, what does the Act say? Section 35 of the Kenya Employment Act provides that a written notice should be given to employees. And this notice usually is for 28 days if the contract is monthly. 28 days if the contract is monthly. Then section 36 provides for payment in lieu. So if you have been given a notice, it means you will work for another 28 days before you leave. But section 36 provides for payment in lieu, where the employer can pay the salary instead of having the employee work for the notice period. Employer can pay you and ask you to leave instead of you continuing to work for the 28 days, which is a month. And further, a service pay is payable upon termination. A service pay, you are given a service pay upon termination, unless you are covered by NSSF or any other pension scheme. Another thing in the termination and dismissal is what we call summary dismissal, and this is as a result of gross misconduct. Summary dismissal, and this is provided for by section 44, that it defines summary dismissal as termination without notice or pay in lieu. So the employer can just terminate your services without giving you any notice. The reasons for termination for this summary dismissal include theft, willful neglect, gross insubordination, or being drunk and incapable of performing your duties, and any other matters. So whatever the circumstance in summary dismissal, the employer must still conduct a fair hearing, must go through the disciplinary process for it to be deemed fair. We have termination on account of redundancy. Termination, that was termination on account of notice, and this is termination on account of redundancy. Section 40 of the Kenya Employment Act defines this as termination due to the employer's operational requirements. Maybe the employer wants to close shop, is unable to operate. Circumstances are forcing them to reduce on the number of employees. Then it's acceptable. But it is mandatory for the employer to notify the employee and the labor officer at least 1 month in advance. So if the employer wants to right size, want to reduce the number of employees and you are affected, then those employees should be given a notice of 1 month in advance. And if redundancy is acceptable, then the employee is entitled to severance pay at 15 days pay for each completed year of service. Severance pay at 15 days pay for each completed year of service. But we have something called unfair termination. What is it? Unfair termination is where the employer fails on the legal test on the two tests. The substantive fairness, where the employer fails to provide a valid reason, and for procedural fairness test, where the employer does not follow the due process. But termination is prohibited on reasons such as being a member of a trade union, termination on race, termination on pregnancy, or any discrimination will be deemed automatically unfair. So, unfair termination is when the two tests fail, or one of them fail, and when it is based on discrimination, prohibited reasons like discrimination. So if you find that the internal mechanism of appeal are failing, then you can seek external recourse. And the first step in seeking external recourse appeal is to file a complaint with the labor officer to conduct mediation and conciliation. So the labor officer is mandated to go and talk to the employer on your behalf, or initiate a mediation process between the employer and the employee to see if the case can be resolved. If the mediation fails and conciliation fails, then the matter proceeds to the Employment and Labor Relations Court. Now you go to the court for adjudication. The court does adjudication. And for you to file an appeal at the court, then you must do it within 3 years of the dismissal. If 3 years elapse and you have not appealed at the ELRC, then your case will not be heard. Remedies for unfair termination. Remedies for unfair termination. 1. Compensation of up to 12 months gross salary as provided for Section 49. You will be compensated for up to 12 months gross salary. The court might decide on other awards, including wages for any notice period denied, and the court may order reinstatement or reinstatement, but this is rare. All terminal benefits, including all accrued leave, unpaid salary, and service or severance pay, must be paid to the employee. In summary, it is important for you to know your rights, to valid reason and unfair hearing, and that anytime a disciplinary action looks like turning your side, always keep copies of all written warnings and decision letters for your defense. Thank you for listening in. I have been your presenter, Dr. John Chegenye, who is a HRM expert, educator, and researcher. Thank you.